All right, the judge is popping up his camera right now. Let's listen in.
Good afternoon. Court is now in session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Will the parties please enter their appearances?
Your Honor, Christopher Ballard and Chad Grunander on behalf of the state.
Your Honor, Kathy Nestor, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Thank you. Welcome to both the prosecution and defense. Mr. Robinson, I understand, is appearing by WebEx. Mr. Robinson, can you hear us?
Yes, I can.
Thank you. Good afternoon to you all. We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters. The first, Mr. Robinson's motion to strike the sheriff's response. The second, Mr. Robinson's motion to appear in civilian clothing and without physical restraints. The third, the sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion. Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. The court took under advisement two issues, the motion to strike and the motion to appear in civilian clothing and without restraints. Court now issues its ruling. In regards to the motion to strike the sheriff's response, the prosecution and the sheriff's department filed a joint opposition to the defendant's motion to appear in civilian clothing and without restraints. Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party. At the hearing, all agreed that the sheriff's department is not a party in this case. The state and the sheriff's office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the sheriff's department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, defendant's motion to strike the sheriff's response is granted. However, under Rule 3-414 of the Utah Rules of Judicial Administration, the court is required to coordinate courtroom security with the sheriff's department. Consistent with that rule and with the defendant's agreement, the court has considered the substance of the state's opposition and the memorandum prepared by the court security director that was attached to it. Going forward, if either party has a security concern specific to this case, they may present evidence from the sheriff's department by affidavit, declaration, exhibit, or testimony. This order does not limit the sheriff's department ability to coordinate with the court or otherwise act as authorized by law. Turning to the motion to appear in civilian clothing and without physical restraints. The parties agree that during trial, a defendant has a right to appear in civilian clothing and that any restraints must be concealed from the jury. Mr. Robinson now seeks to extend those rights to all pretrial proceedings. The court considered each request separately. In relation to request to appear in civilian clothing, Mr. Robinson asks to appear in civilian clothing at all pretrial hearings. He argues that the extensive media coverage of this case creates a real risk of prejudice if the public and potential jurors repeatedly see him in jail attire. The state, the sheriff's department, and the court security director opposed the request, arguing that jail clothing assists with safety and identification. The court has balanced these competing concerns. The case has attracted extraordinary public and media attention. Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Defense counsel is directed to coordinate with the jail to ensure that this order is implemented, and the court further orders that if the clothing be provided 72 hours prior to any hearing. To the second request to appear without physical restraints, Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. Rule 3-414 sub 9C of the Utah Rules of Judicial Administration requires that all in-custody defendants be restrained unless otherwise ordered by the court. The court recognizes that Mr. Robinson has no criminal history and no record of misconduct while in custody. However, the charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority. The emotional nature of these proceedings also raise the risk of disruption. Given these factors, the defendant's request to appear without restraint is denied. The court directs the sheriff's department to conduct an individualized assessment and use the least restrictive restraints necessary to maintain safety. If those restraints impede the defendant's ability to communicate with counsel or take notes, counsel may renew the motion. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom. In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. In conclusion, the court orders as follows. Defendant's motion to strike the sheriff's response is granted. Defendant's motion to appear in civilian clothing is granted. Defendant's motion to appear without restraints is denied. The standing decorum order will be amended to prohibit any visual recording or photography of the defendant's restraints or of the defendant entering or exiting the courtroom. This constitutes the order of the court, and a written order and ruling will be published shortly. Both defense and prosecution have stipulated to vacate the October 30th hearing. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues. And that concludes the order of this court. Counsel, thank you for being here. Mr. Robinson, we'll see you on January 16th and January 30th at 1 p.m. Court is now in recess.
All right, you're just listening in there at this ruling there in the courtroom, and a couple going over it right now, talking about this as the alleged Charlie Kirk assassin, Tyler Robinson. You did hear his voice. You did not see him as the judge asked him via WebEx if Tyler Robinson could hear him. He says, yes, I can, to the judge as they went over some of these motions, including the judge allowing Tyler Robinson to wear plain clothes during pre-trial hearings and motions. Of course, this is to not taint the projected juror pool, to continue with the presumption of innocence. He also denied, though, that he will be restrained in this insofar as not impeding his communication there with counsel, noting the fact that Tyler Robinson, no previous criminal history, but the severity of these charges, that aggravated murder charge on the list for the shooting there of Charlie Kirk back on, obviously, September the 10th. So alleged in this. Let's continue on here on Live Now from Fox. Bring into the conversation friend of the program, criminal defense attorney Randy Zelin. Randy, thank you so much for joining us here on Live Now from Fox. And this is a very important case there in Utah, high-profile case, probably the biggest they've seen. In terms of the allowance that he will be in civilian clothes, what do we make of this?
It is an important decision, one that we really do take for granted. But if you've ever been in a courtroom dressed in prison clothing, which I never have, it certainly does not make you feel like you're innocent. But as an attorney, having sat next to clients who come in wearing their prison clothing, again, it does not send the message that, hey, my client is presumed innocent. Back in 1976, the Supreme Court determined that and said, wait, absolutely. The public, in particular, a jury, cannot help but looking at someone wearing prison clothing and be affected by that. And it does cut against the presumption of innocence. The important takeaway being that the defense must make a timely motion for permission to wear street clothes. Otherwise, the Supreme Court in 1976 said, you waive that.
Yeah, and obviously they mentioned just the media, the notoriety of this case with Charlie Kirk there, the conservative activist. This is going far and wide, potentially concerned over Tyler Robinson being viewed in some of this prison outfit. The Sheriff's Department arguing that it's about safety and identification. Can you take me more into why they do want him in this outfit that they obviously were denied there in terms of this, but why they would want him in prison clothes, in a jumpsuit, rather than civilian clothes?
I can't speak to any logical reason on behalf of the Sheriff's Department or on behalf of any law enforcement department that would argue against the prejudice that is going to affect a defendant who is presumed innocent, yes, the argument could be made, hey, wait a minute, Judge, we're not on trial. What is the big deal? Well, the big deal is to the extent that photographs are permitted, to the extent that video is permitted, a potential juror, someone who's sitting at home, someone who's sitting in their office, seeing Mr. Robinson come into court wearing prison clothing, that person is going to have that visual in his or her mind. And if that person ends up being picked for the jury, then yeah, that is a visual that you don't want that juror to have in his or her head. From a safety standpoint, okay, let Mr. Robinson wear street clothes. And to the extent that you're concerned about the public safety, your own safety, his own safety, then have him shackled. As long as when people are taking pictures and they see him seated, they're not going to see handcuffs. They're not going to see leg restraints. Those can be hidden from view, but let the man present the perception to go along with the right for him to be viewed as innocent.
Very good. And of course, they also talked about the media not being allowed to kind of shoot some of these things, to publicize those in that way. Tyler Robinson and his defense team, it was denied, though, the request to kind of remove some of those restraints. Why potentially was that the judge's ruling? They mentioned the fact that he doesn't have a criminal history, but the severity of these charges, aggravated murder on the table, and also the potential for disruption inside of the courtroom. Why potentially did the judge make this case?
We all understand that Mr. Robinson is presumed innocent. We also understand that he's alleged to have assassinated another human being, which is about as depraved, as awful, as planned, every bad thing you could possibly think of for criminal offense conduct is all wrapped into that one charge. So yes, is that person capable of doing something in the courtroom? Yes. Is that person capable of doing something because that person no longer has anything to live for or nothing to lose? Yes. Have we seen instances where defendants have gone crazy in a courtroom and have tried to do crazy things either to him or herself or to the judge or to a witness? Yes. So this way, the court hedges the court's bets. On the one hand, the court allows Mr. Robinson to be looked at by a potential juror as innocent, but the safety of the courtroom, of the judge, of the witnesses, of the people in the courtroom, of the defendant, of the sheriff's staff, they are also maintained by having him in restraints.
Yeah, that is a very good point. That was actually going to be my question, just trying to find the balance as the judge, obviously presiding over this case, wants to make sure that the obviously proof of innocence there, having innocent until proven guilty. Do you think that was kind of the ultimate, the gray area? And do you think even if they refile this motion, which it feels like they potentially could, that there are potentially some gray areas in between those?
Well, what you have to really do here is distinguish between what takes place pre-trial and what takes place at the trial. At pre-trial, there's probably going to be more of a sense of, we'll let him wear street clothing, but we want him restrained. With the trial, you don't want to risk the jury seeing him in restraints for something as simple as in most, if not all courtrooms, when the jury enters, when the jury leaves, everyone stands, including the defendant. It's going to be difficult to hide Mr. Robinson in restraints when he goes to stand up, when the jury enters and when the jury leaves. You don't want the jury accidentally seeing the defendant in restraints. Again, it is a visual that cuts against the notion that a defendant is presumed innocent. So I would think pre-trial, we will see the compromise of street clothes with restraints. And so long as he behaves properly, we will see that order changed from street clothes, no restraints. Again, so long as Mr. Robinson behaves himself. The first time he doesn't, if he doesn't, then you can be damn sure that that order will go back to you're in restraints.
All right, very good. I just want to ask you about one of my last questions before I let you go here, Randy, because you talked about potentially the jury and prospective jurors there seeing some of these images out there. Just the fact that the jury pool, the size of the jury pool, do you think that weighed on the judge's mind at all?
Absolutely. The judge, I think, in this case, as a judge should in every case where a defendant is entitled to a jury, and it need not be a capital murder case or a murder one case with or without the death penalty. In every case, a defendant is presumed innocent, and a judge should bend over backwards to make sure that the defendant is given a fair trial and that the jury is not tainted or infected by anything that doesn't belong in the courtroom that would tip the scales away from that presumption of innocence. So I think the judge was correct, and I think the judge is paying close attention to ensuring that there are no appellate issues created by virtue of the defendant saying, I didn't get a fair trial, I lost my presumption of innocence because the jury looks at me, sees me in prison clothing, and the Supreme Court has already said, going back now almost 50 years, that is a no-no.
Yeah, that is a very good point. Some of these high-stakes trials, they really want to go along with that fair and impartial until they don't get to the appeals process, which throws the entire wrench into it. Randy, thank you so much. I appreciate your time. We're not going to see potentially any more hearings until the first of the year, until 2026, but we appreciate your time here on Live Now.
Thank you for having me.
All right, thank you so much. All right, great conversation as that hearing taking place. Kind of a compromise, a mixed bag in the alleged Charlie Kirk assassin, Tyler Robinson, via WebEx. We did not see his face. This is potentially going to be the first time public was able to witness that. But this coming in from Fox News Digital talking about it. The motions seeking to limit news cameras in the court have been put off until January. In the meantime, the media cannot photograph Robinson's restraints if he does appear before that matter is taken up. But of course, the ruling also coming down, granting the request of civilian clothes granted during pretrial to continue with the presumption of innocence in this case. I'm Andy Mack. We're back after this.